Welcome to this webinar hosted by the Grantham Research Institute at the London School of Economics. My name is Higham. I'm a Senior Policy Fellow at LSE, and I have the pleasure to be chairing this morning's session. I have a few bits of housekeeping before we kick off. We will be hearing presentations from our three speakers first, but you can ask questions in the Q&A chat box throughout the presentation, and we'll get to them at the end. So please do post your questions there. And I think you can also upvote questions that other people have asked if it's pretty similar to what you wanted to know as well. The focus of this morning's session is the implementation of the judgment in the KlimaSeniorinnen case. The judgment was issued by the European Court of Human Rights in April of last year. And since that judgment was issued, there has been some controversy over what happens next. At GRI, a lot of our research focuses on the implementation and the impact of climate litigation. And so we really wanted to explore this case as a really interesting case study. And I'm delighted that we have an excellent panel of experts with us today to kick off the discussion. I wanted to start, before I hand over to the experts, with a brief introduction to the case for those who might be unfamiliar with it. It's a litigation with a fairly long history. So the case began with a request to the Swiss government back in 2016, nearly a decade ago now. That was filed by a group of senior Swiss women who were deeply concerned about the impact that climate change was having on human health and human rights. And they felt the Swiss government was not doing enough to address this. The case is an early example of what we now understand as government framework litigation or systemic litigation, cases that challenge a lack of ambition or the inadequate implementation of a whole of government climate policy response. And we now know that there are more than 100 such cases around the world that have been filed in the last 10 years or so. The original case went through various appeals until it was finally dismissed by the Swiss Supreme Court in 2020, and the applicants then filed an application to the European Court of Human Rights. It was one of three cases heard together by the Grand Chamber of the Court in April of last year, the first substantive decisions on climate litigation from the court, and the only one to result in a very clear success for the plaintiffs. Since then, however, as I said, we've seen controversy around the implementation of the judgment in Switzerland. In June, both chambers of the Swiss Parliament adopted a declaration arguing that the court had overstepped the boundaries of its interpretative role in the decision. And they also argued that in any event, in their view, Switzerland is in compliance with the sort of underlying principles in the ruling. Despite some apparent contradictions between the court's finding of fact that Switzerland is not in compliance with the principles that they set out, a similar position has now been adopted by the executive branch of the Swiss government. So this leaves us in a fairly unusual state of affairs, and one that I think has implications both for our understanding of the implementation and effectiveness of climate change litigation, but also for the broader European convention system. So with us to discuss this today, as I said, we have a wonderful panel of experts. In the programme, we were originally going to start with an intervention from Dennis van Berkel on behalf of the Climate Litigation Network. Dennis was unable to join us today, but we're very lucky that we have Floris in Dennis's place. Floris is a senior legal associate at the Climate Litigation Network, and he has been working with a coalition of NGOs who've been involved in the case and played a leading role in the submission of arguments to the Department of the Execution of Judgments, which we'll share in the chat. And he'll be giving his thoughts on where Switzerland is still not in compliance with the requirements of the April ruling from the court. After Floris, we'll hear from Vetle Seierstad. Vetle is a legal advisor at the Norwegian Human Rights Institution. Vetle has been involved in an assessment of how the decision from this case could apply in the Norwegian context. And he'll also give us a broader perspective on what the judgment might mean for Council of Europe member states beyond Switzerland, and address some of the thorny questions it raises for national climate policy, as well as reflecting on the role that national human rights institutions like his can play in ensuring that the principles of the judgment are implemented in different domestic contexts. And then finally, we'll hear from Başak Çalı, Professor of International Law at Oxford's Bonavero Institute of Human Rights and the co-founder of the European Implementation Network, which is a civil society organization that advocates for the full and effective implementation of human rights judgments. Başak has years of experience working within and studying the European Convention system, and she'll share her thoughts on why the position regarding implementation of this judgment is so unusual and what the next steps in the process for implementing the judgment could be. So without any more from me, I'll hand over to Floris for the first intervention. Floris, you have about 8 minutes. The floor is yours.
Thank you for having me and for the kind introduction. And like you mentioned, we just submitted this Rule 9 submission to the Committee of Ministers. And I just want to say that I think this is really fantastic because we submitted it with a coalition of 33 NGOs. And this sends a really strong signal that civil society is aligned on the interpretation of the judgment and the importance that Switzerland faithfully implements it. So like Kate mentioned, I'll be speaking to you about the obligations that flow from the KlimaSeniorinnen judgment and how Switzerland continues to fall short of those. I should say at the start here that given the time frame for the presentation, I will focus only on the absolute core obligation, which is the obligation that states must quantify a carbon budget which reflects their fair share. I'll spend most of my time talking about how that obligation flows from the judgment, and then I'll end on how Switzerland continues to fall short of implementing it. Now, I realize that talking about carbon budgets can be quite technical, so I would call on everyone to also have a look at the Rule 9 submission, which, in my opinion, sets out quite convincingly how this flows from the judgment. Just at the start, if you were to take only 2 points from my presentation, I would really like them to be, first, that the KlimaSeniorinnen judgment requires states to quantify a fair share carbon budget, and second, that Switzerland hasn't done so and still doesn't do so to this date. So on the judgment itself, first, just some very basics. The court identified under Article 8 of the Convention a right to effective protection from serious adverse effects of climate change. Okay, so what does that mean? Well, the court relies on the principle that human rights must be rendered practical and effective, and it then formulates the primary duty for states, which is that they must take measures capable of mitigating climate change. This is logical, right? A state can't solve climate change on its own, but it can be held to take measures capable of mitigating it. Then on the margin of appreciation, the court finds a reduced margin of appreciation for the reduction targets set by states, and the wide margin for the measures they have to take to achieve those targets. In other words, a wide margin for how they reduce emissions, but a narrow margin for deciding by how much they reduce their emissions. So what does it mean then to take measures capable of mitigating climate change? The court says so in paragraph 550 of the judgment, which most of you will be familiar with. It sets out a number of obligations. A lists the most important one, which is the one I'll be focusing on, because that's where the court requires states to quantify a carbon budget. So let me first dip really briefly into what that means. To mitigate climate change, global warming must be held to 1.5 degrees Celsius. And if we are to achieve that, there is a finite amount of greenhouse gases, primarily CO2, that we can still emit. And if you go beyond that, we will exceed 1.5 degrees of warming. Now, I mean, you can picture this as a bathtub filling up. There's only a certain amount of water that can be added before it starts to spill over. And that amount that's still left, that's the remaining global carbon budget. Now, if states are to take measures capable of mitigating climate change, they have to make sure that this relates to the remaining global carbon budget. because if they simply set targets for net zero in 2050, or in our metaphor, they say, I'll turn the faucet off in 2050, that doesn't account at all for how much space is actually left in the bathtub. And setting national targets which are not related to the global carbon budget is completely divorced from effective protection of human rights, because states essentially have no idea whether they're effectively contributing to staying below 1.5 degrees of warming. So moving back to the court now, the court was very aware of this. And I think it's really helpful to know, and I'm going to tell you something now that you can't read back in the judgment, but the court asked a number of questions to Switzerland in advance of the Grand Chamber hearing. And it asked, knowing the remaining global carbon budget, whether Switzerland had quantified a carbon budget and how it had determined its fair share. So essentially, it asked Switzerland to justify its mitigation policies by showing that they had quantified a budget and by showing that that had been fair. Now, the reason that I tell you this is first that it shows that the court understands what the carbon budget is meant to do. And second, because the responses to the questions by the parties play a very prominent role in the judgment. So in response to the question, Switzerland had made 2 points. First, it had said, it's not possible to derive a national carbon budget from the remaining global carbon budget because, as they alleged, there is a lack of consensus on how to determine a state's fair share. The court disagreed. It held that it is possible to determine a state's fair share because that's why we have the principle of common but differentiated responsibilities and respective capabilities as laid down in the UNFCCC in the Paris Agreement. And the German Constitutional Court already held this in the Neubauer case, and the European Court of Human Rights finds that convincing. Second, Switzerland had argued that its own approach of setting reduction targets, including a net zero target in 2050, was close to an approach quantifying a carbon budget, and that it had included fairness considerations. But it in no way explained, it didn't quantify, it didn't substantiate in any way how that target was then fair. And the court found that that approach was not capable of effectively mitigating climate change, because for that, Switzerland would have had to quantify the limitations on national greenhouse gas emissions through a budget, which it hadn't done. Now, in addition, the applicants had shown that if you calculated the cumulative emissions flowing from Swiss policies, its portion of the budget would be twice the size of its population, and that the budget would run out in 2034 at the very latest. So based on this, the court concludes, and I quote, "Thus, under its current climate strategy, Switzerland allowed for more greenhouse gas emissions than even an equal per capita emissions quantification approach would entitle it to use." End of quote. So what the court says here is that Swiss policies fall short because they exceed the limit set even by equal per capita, which is the most lenient approach to quantifying a fair share. And that constitutes a breach of the convention. So to conclude on the standard flowing from the judgment, the court required Switzerland to quantify its national carbon budget and show how this reflected its fair share of the remaining global carbon budget for 1.5. Switzerland had failed to do so, and the court finds that that is a critical lacuna and a violation of human rights. So let me turn now to the implementation of the judgment. Like I just mentioned, the court found a violation because Switzerland had failed to quantify a fair share 1.5 aligned carbon budget. So what does Switzerland need to do to remedy the violation and to avoid future violations? Well, exactly that. It still needs to quantify a fair share 1.5 aligned national carbon budget. And then on that basis, determine its reduction pathway to net zero in a way that respects the budget. In other words, it has to ensure that the bathtub doesn't flow over. Now, Switzerland has submitted an action report to the Committee of Ministers in which it says that it has already implemented the judgment and doesn't need to do anything further. And in respect of the carbon budget, it says so on the basis of 2 things. First, there is no consensus on how to determine a fair share. Second, based on its existing reduction target, Switzerland has added up the amount of cumulative emissions flowing from that, and they've called that a budget. Now, as you may have noticed, these are the exact arguments Switzerland already put forward during the proceedings. And the court already rejected the argument that a fair share could not be determined, referring to CBDR-RC. And the court already rejected that the Swiss approach was close to an approach establishing a carbon budget. Because the entire concept of the carbon budget is meant to show how much CO2 we can still emit. It is meant to show the limitations on emissions. And from those limitations, states must derive how much they can emit. And Switzerland does the exact opposite. It sets targets and then calculates how many emissions will follow. But if states are to take measures capable of mitigating climate change, they have to quantify their own fair share budget and then respect that. And Switzerland's approach just blatantly falls short, which means that the critical lacuna in human rights protection continues to exist. So I want to end now on the reason that implementation by Switzerland is so important, because the court really delivered a landmark judgment in KlimaSeniorinnen. It lays down a very strong standard requiring states to do their fair share. And the court really understood the importance of laying down limitations on greenhouse gas emissions and quantifying those limitations. And we now have to ensure that those really strong standards aren't watered down during the implementation process, and that Switzerland meets its human rights obligations. Thank you.
Thank you very much, Floris, for that excellent summary of the submission. And do read the submission at the link posted in the chat if you want to understand more. We'll now pass over to Vetle for your perspective. Thank you.
Yes, thank you so much, Kate. As Kate mentioned, I will be talking about 3 subjects, so I'll try to be quite brief and stay within my time. We at the Norwegian Human Rights Institution analyzed the implications of this judgment for Norway. And in that relation, I'll talk about where we found Norway to be shortcoming, some key thorny aspects of the judgment. And if I have time, I will reflect a bit on the role of national human rights institutions in implementing this judgment. So in our analysis of what the judgment required, we identified 4 key reasons for why the Norwegian legal framework was unlikely to meet the requirements set out by the court in KlimaSeniorinnen. So firstly, like Switzerland, Norway has not adopted a comprehensive carbon budget based on an evaluation of its fair share in line with the 1.5-degree target. It has not really even attempted to argue that it has. It just hasn't been a part of the Norwegian legislation. Secondly, Norway has not established a roadmap or a pathway for how emissions will be reduced up to 2050 and currently lacks, for example, intermediate climate targets. Thirdly, we don't think Norway can show evidence that they have duly complied or are in the process of complying with climate targets. The Norwegian domestic emission reductions are very low in a European comparative perspective, with the latest numbers showing a reduction of 9.1% compared to 1990. And by comparison, the court was critical of Switzerland only reducing their emissions by 19%, thus missing their 20% by 2020 target. And fourthly, we don't think Norway can prove that it is acting in good time by devising and implementing legislation and measures. And this is a bit complicated because it's to a large degree because Norway wants to base its climate policies on cooperation with the EU, but being a non-EU member, that relationship has to be negotiated specifically. And so far it's undetermined beyond 2030. And that sort of wait and see approach creates a risk that climate legislation and frameworks are postponed or delayed, and thus creates uncertainty of whether Norway will act in good time. Now, based on these 4 points, we found Norway not to be in compliance with the obligations set out by the judgment. And now I will go over 2 quite thorny questions that came up in our analysis. That is, firstly, the use of carbon markets or emissions trading to meet climate targets. And secondly, the question of imported or exported emissions. Now, we had to extensively consider the use of emissions trading in our analysis of Norwegian compliance, as it is, let's say, the key part of Norwegian climate strategy, essentially, to compensate for, as I mentioned, their rather low domestic emission reductions. In our analysis, we highlighted 3 key arguments for how to interpret the judgment in relation to emissions trading. Firstly, when the court talks about the Swiss emission reductions, they refer only to the territorial numbers, which are an 11% average reduction in the period 2011 to 2020 compared to 1990. And this is despite the fact that Switzerland alleged before the court that it had met its Kyoto objective of 15.8% reductions in the same period. And that difference was made up for by buying emissions or allowances. The fact that the court only references the territorial numbers could be read to say that it focuses or sets requirements related to domestic measures. However, the court also introduces, as Floris said, a sort of dual margin of appreciation, where the margin is narrow for the setting of an overall regulatory framework, which includes sufficient climate targets, but wide for the choice of means. And we took the view that emissions trading most likely falls into the means category, which means that its utilization would fall into the wider margin of appreciation that states have. And thirdly, the court generally interprets the convention in line with what's called European consensus and other relevant international agreements between the parties. Now, in this context, emissions trading is central to the European Union's climate strategy, both between states and between companies, and it's also accepted under the Paris Agreement. Thus, if we apply the court's usual interpretive method, that sort of argues against reading the judgment as precluding the use of emissions trading. Taking these 3 points together, we don't think the judgment should be read as entirely excluding the use of emissions trading. However, the use should probably be limited, and we identified 2 key principles that argue in favor of a limitation on the use. First, the court in the judgment itself really emphasizes the importance of intergenerational burden sharing. All countries must, sooner or later, transition their economy to net zero. If that is delayed by an over-reliance on emissions trading, the cost could be pushed onto future generations who might face an expensive or abrupt transition in the, for example, 2040s. And secondly, the precautionary principle. A delayed national transition today due to overuse of emissions trading would, in our view, entail a risk of non-compliance and dangerous climate change in the future. So to protect rights, states should therefore take precautionary action, essentially. So in total, we think emissions trading can be used, but in a limited fashion. A good way to use it while ensuring compliance is probably to set a high ambition primary target, which includes emissions trading, and a separate domestic target, which is sufficiently ambitious to ensure a timely economic transition. And now I'll speak a little bit about exported and imported emissions. So when I talked about Norwegian compliance, I kind of dodged the elephant in the Norwegian room, in other words, the petroleum exports. Emissions from these exports are over 10 times larger than the domestic emissions. So the central question for Norway really is whether they have responsibilities for emissions from exported petroleum. This was not really addressed in KlimaSeniorinnen, but the applicants did argue that Switzerland was responsible for so-called embedded or imported emissions. Switzerland rejected that, saying that they had no jurisdiction over these emissions as they happen abroad. This was rejected by the court because jurisdiction is determined by control over the victim, not over the source of harm. So the court said that responsibility for these emissions were a question for the merits. Unfortunately, the court didn't pick up this on the merits, but they did have some general statements in the jurisdiction section, which might imply that in future cases, this is something that they are aware of. And somewhat funnily, the dissenting opinion of Judge Eike does read the majority in a quite progressive way as having included embedded emissions in their responsibilities. So we took the view that the court opened the door for obligations here, but did not say anything definitively about what those responsibilities would be. We advised the government of an increased legal risk, and the court might clarify these questions, for example, in the upcoming Greenpeace Nordic and Others versus Norway case, which precisely deals with the opening of new areas for petroleum exploration. Now I have some time left, I think, so I'll shortly reflect on the role of NHRIs in implementation, as we have tried to do. I think NHRIs have a very important role and are sort of uniquely placed to advance implementation. We usually say that NHRIs have 4 roles: the advisor, the communicator, the facilitator, and ultimately the watchdog. Our primary approach in regards to the Norwegian government was to take an advisory role, where we produced a quite extensive report looking at whether Norway was complying and how it could ensure compliance, which we mainly sent as advice to the government. However, because we are independent, we're not a part of the administration, we're free to publicize that advice, we're free to talk about it, we're free to raise concerns as part of the watchdog role about the Norwegian non-compliance. And the work we do in our advisory role can then be used by civil society, by NGOs, who are better positioned than us to ensure compliance through, for example, pressure, be it public pressure, electoral pressure, or pressure in the form of climate litigation. So the key for us has been to kind of use the authority NHRIs have as a legal authority, if you will, and also the increased freedom we have compared to other government agencies. I will also be evaluating the judgment, like the Ministry for Climate and the Environment. So we have tried to, or central to our strategy was that our advice must be like legally sound and very methodologically robust. And I think another benefit for NHRIs is the European network we have through NHRI, through cooperation with the different NHRIs. This enables for us very efficient information and experience sharing, avoids a lot of parallel work, and we can look at best practice implementation, best practice solutions, and learn a lot from each other's interpretations. And right now, of course, it's the Swiss NHRI who's taking in the NHRI sphere at least, a lead on ensuring implementation of this judgment. And what happens in Switzerland will probably sort of set the standard for what will happen in a lot of other countries. So all of us at the different NHRIs are watching that work closely.
Thank you so much, Vetle, for that intervention, both for your points on how we can understand the use of international emissions trading and the difference between domestic emissions reduction targets and overall contributions to global emissions reduction targets, which I think is a critical point for this judgment and a critical point for all states going forwards, and also for those points on looking at how NHRIs can support implementation across Council of Europe member states, which I think is also a really critical point. So now I'll hand over to Başak for her thoughts on where we are in terms of the implementation, the usual implementation processes for Council of Europe judgments, and what might be quite unique about this case.
Thank you. Thank you very much, Kate. So let me just start by saying that I, would like to reiterate or, really underline that this is indeed a landmark judgment. But it is a landmark judgment for many reasons. So clearly it's a landmark judgment for Switzerland and what will happen in relation to Switzerland's effective climate action and policy. As Vetle underlined, this is also a landmark judgment for all the other Council of Europe member states, the other 45, because this judgment will have significant impacts on what will happen in all the other Council of Europe member states. And there's also pending litigation before the European Court of Human Rights, and there will be more, using this as an example, a very important precedent. But in my intervention, I'm going to talk about why this is also a very important landmark judgment for the Committee of Ministers of the Council of Europe and the types of actions that it will be taking in the coming months or coming years. So in my intervention, let me do 3 things, perhaps just to give a very brief understanding of the role of the Committee of Ministers more generally as the intergovernmental peer review organization that's tasked to monitor the implementation of all judgments. So not just climate judgments, but all the other 10,000 or so judgments, depending on how you count them. Secondly, let me give a little bit more sense about what has happened so far and what may happen, as we go into the next meeting of the Committee of Ministers that will take place in March, and then and it will continue to take place every 4 times a year, and so on and so forth. So the European human rights system is very unique in so many ways, in the sense that we have a court that delivers binding judgments, and it's very clear that these judgments are binding. It's provided for in the convention itself. And this is provided for in Article 46 of the Convention, but it also gives a very clear role to the intergovernmental peer review organ, that's the Committee of Ministers, made up of state representatives, to monitor the implementation of these judgments. And again, this is provided for in Article 46. So the Committee of Ministers does many things, standard setting, and lots of other work. But a very important part of its job is to make sure that the European Court's judgments are implemented and the authority of the European Court is respected and upheld by all of its member states. So that's the key role of this organ. Now, a lot of people might immediately think, a political organ made up of member states of the Council of Europe, is that a good idea that they will be safeguarding, the judgments? And I think this is a really important point, which we may come back to also in the Q&A, but this is a very healthy thing, I think, because the convention is owned by all member states, and I think it's a very important task for the political organs to uphold legal judgments. Otherwise, legal judgments don't get implemented on their own, as we know from generations of research on effective implementation and judgments. Now, the Committee of Ministers meets 4 times a year, and it meets in closed session. So we will not be able to watch a webinar like you have watched a webinar of a court hearing about what the Committee of Ministers representatives discuss as to execution. But in their role, they're supported by the Council of Europe Secretariat. Sometimes we call it the Execution Secretariat. It's a bit of a scary name, maybe, but this is the specialized lawyers that seek to ensure that the Committee of Ministers, the political organ, is well informed about what needs to happen for a judgment to be implemented. And something that is incredibly important and very unique about this system is that over the years, participation of civil society organizations, bar associations, international organizations, as well as injured parties, these are applicants, have been enabled into the implementation process. And this was highlighted by Floris just earlier on, that NGOs can make submissions to the Committee of Ministers, as well as the applicants and other international organizations. And the Commissioner for Human Rights can also participate. So we have a participatory kind of model in making sure that the judgment is implemented. Now, maybe as Vetle was talking about a slightly thorny issue, I might also raise a slightly thorny issue with the implementation process as well. And this is the point that a lot of the judgments of the European Court of Human Rights, including the Vetle KlimaSeniorinnen judgment, falls under the category of declaratory judgments. A declaratory judgment is one that doesn't have a very specific section, an operative set of paragraphs that says, here are the violations, here is why there are violations, and therefore you must do 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 in the very specific terms. Well, what the court says is, read my judgment. You will understand what you have to do. So there's a bit of a trust in everyone's good faith in reading a judgment and finding out what are the steps that need to be taken. And this is reiterated in this judgment for those who are well versed into this case under paragraph 656 and 657, that the court says, this is a judgment. It's full. I've given you pages and pages and pages of assessment and legal reasoning. Go do your homework, the Committee of Ministers, everyone who is involved in the process, and move on and implement my judgment. So this is what the court has said, which means that we are really at a very, very crucial moment, because this is the task that has been done by NGOs, by the applicant, by probably the Secretariat and the Committee of Ministers in these months to really figure out what is really required by this judgment. And of course, what is decided for the Swiss case will have important implications for future cases. So this is a precedent-setting case in relation to not only litigation, but also for implementation. And this is absolutely crucial. So let me now go back to where we are now and what may happen in the few months, or I would rather say in the few decades, hopefully, because judgment implementation doesn't happen in 6 months or 10 years. And if you look at the statistics, a lot of the judgments of the European Court of Human Rights would be closed, which means a closed case will be a case that's fully implemented in all of its dimensions. This could take 2 years, 5 years, 10 years. It could take even more than a decade. So we are in a very long journey in this sense. But what is unique about the Swiss case is that normally a government will submit an action plan after 6 months after a judgment is final to say, well, we've read the judgment, we've sat down, we talked about it, we had consultations, and this is what we really think in good faith, what we need to do to fully implement this judgment. And then there will be discussions back and forth with the Secretariat, with the NGOs, with the Committee of Ministers to agree on that plan. And then, the process will move on, for years and years and years to make sure that all of these items have been ticked off the list. What is unique here is that instead of submitting an action plan, the Swiss government presented an action report. As Floris underlined, the Swiss government said, I've implemented this judgment, it's done. There's nothing to talk, there's nothing to deliberate, there's nothing to further discuss. When you meet in March, just say thank you and just close the case. So given how complex this judgment is, and you have heard from Floris, you've heard from Vetle, there are so many issues that need to be really pinned down and discussed. This is highly unusual because this is not a very simple case that you pay some compensation to a victim and the case is closed and there's nothing to do. It's precisely the opposite. There are lots of things that need to be discussed, aired, using best scientific evidence. There's huge amounts of layers. So this is highly unusual in this sense. And this is something that I do hope that there will be a very strong, process of deliberation so that this is not how it will proceed, and that the Committee of Ministers will indeed invite Switzerland to submit an action plan to carry on with the work, because this is really important, not just for Switzerland. It's important for every single member of the Council of Europe. And there was a recent summit in 2023 in Reykjavik, called United Around Our Values, where effective climate action was identified by all political leaders as one of the most important areas for all member states to work towards, and so on and so forth. So we will really need to be watching this aspect of the case very closely. So this is kind of the first part. And of course, the second and maybe an unusual aspect of the action report, and this is the point that I'd like to end with, is that, as Kate, you highlighted, there has been a kind of a backlash against this judgment in Switzerland, both in the two chambers of parliament and also for the government. There were a number of non-binding resolutions that were issued. So these resolutions didn't have the power of law in the Swiss context, but there was a lot of discussion and so on made. And the action report summarizes and presents all of these things. And you can say, that's fine. They're just telling us what's happened in Switzerland after the judgment. This is background information. But it's sometimes, I think, when we read the action report carefully, it is also has the tone of saying, well, this court has gone too far with this judgment. It has gone beyond its interpretive powers. It's gone beyond its dynamic interpretation. And those paragraphs are in the sense unusual, because it reads as if not just a mere summary of what happened in Switzerland, but a slight rejection of the court's judgment itself. Now, I wouldn't want to read it that way, and I think this is not maybe what we shouldn't want to read it that way. But this is also a little bit concerning, because the judgments of the European Court of Human Rights are final, and this authority is not something that we can relitigate over and over again in the implementation phase. So this means that what will happen in March, and hopefully beyond March to many, many years, is incredibly crucial, not only for what is the future of effective climate policy within the Council of Europe member states, but also for the authority of the European Court of Human Rights, who has really made, I think, a very serious and its best effort to balance very complex considerations of convention interpretation and effective climate action. So we will see what will happen in March and beyond in the light of these developments. And I think the NGO participation and NHRI participation, not for the short term, but really in the long term, will be absolutely crucial as to how the Committee of Ministers becomes an effective guardian of human rights-based judgments in the future as well. Thank you.
Thank you so much, Başak, for that. I think you've really done an excellent job of putting in perspective why the Swiss position is unusual, the submission of the action report rather than the action plan, and why this is important, not just in terms of how we ultimately see this judgment being interpreted and applied, but also how the European court system functions as a whole. So really, really important. We have, I'm pleased to say, a lot of questions in the chat to get through. And I'm going to start with one that is addressed to all of the speakers and ask each of you to give your response. And then I'll get into a few more specific questions addressed to each of you. So Dalia Palombo says, thank you for the presentations. And what is the relevance of the IPCC reports for the Committee of Ministers to assess whether Switzerland's plan to reduce its emissions is in line with the KlimaSeniorinnen case? So what kind of, I would also interpret that more broadly, what kind of evidence should the Committee of Ministers be thinking about when they're trying to think about whether to accept Switzerland's position or not? I don't know, maybe Floris, you might want to take that first, and then we can go around and Vetle and Başak can see what they'd like to add.
Yeah, sure. And thank you for this great question. I suppose, especially when it comes to the carbon budget, I mean, the court relies quite heavily on the IPCC as providing best available evidence at this moment, or best available science, I should say. What we've done in the Rule 9 submission is, in addition, we have submitted an expert report where climate scientists have calculated the remaining carbon budget for Switzerland based on different fair share methodologies. And when it comes to the remaining global carbon budget, they have updated how large the budget is at this moment. So the latest IPCC report has now outdated because there has been years of emissions since then. And these expert reports update the remaining global carbon budget and then determine Switzerland's fair share budget. And on that basis, the Committee of Ministers should also determine whether Switzerland's plans actually comply with what is left in terms of a carbon budget. And I would note that under most fair share principles, the budgets have already been depleted. So there's only very small budgets left, only under the most lenient principles. And this is what the reality that we now have to deal with, and what the Committee of Ministers should certainly engage with.
Vetle or Başak, do either of you want to come in on that?
Yeah, I can comment a little bit. Yeah, I think the use of the IPCC is a very interesting question. And I didn't get to comment on it in my intervention, but it's something we commented on extensively in our advice to the government, because we think the court quite extensively, obviously in relation to the carbon budget, but also generally just to describe what's happening as evidence for what's happening, how rights are affected. They extensively use the IPCC. So in a sense, it's an interesting intermingling of existing legal standards with existing scientific standards. So we took that in our advice to the government, that obviously policy needs to be based on the legal standards and specifically the scientific standards. They will be measured legally against these scientific standards. And in our own analysis, we also adopted our methodology to that by extensively using these scientific authorities we have in Norway and the advice they have given to evaluate the Norwegian compliance.
maybe just very briefly, in terms of the methodology of the Committee of Ministers, what matters is what the judgment says as to how, what are the steps that need to be taken in every case. But the KlimaSeniorinnen judgment has laid out quite a lot of principles as to how these assessments shall be made. So it wouldn't necessarily be that the Committee of Ministers independently will go to these reports, but it will, normally will justify, how it will assess the Swiss action based on the guidelines that the court has set. But I think there's a clear, a good overlap, and also there's a call for always using best available science as a principle in the judgment. So the court, as Vetle was saying, has also merged these fields in the principle setting segments of the judgment. And that's what the Committee of Ministers will have to do, to always go back to the judgment to decide what it has to do.
Thank you all. That's an excellent set of responses to that question. I'm going to ask a few questions together for the next round. So we have a question from Gerd Winter. It's directed to Floris, but again, feel free to input on it, anyone who would like to. And it's about the reference to the 1.5 degree temperature target and the fact that the 1.5 degree temperature target has, as we know, almost already been reached. And Gerd asks, he makes the point that this means that there is no, I'm not quite sure what that's meant to say, but we can't necessarily achieve that 1.5 degree target with each country relying only on the sort of feasible, economically feasible measures within that country. And he argues that residual emissions need to be put together as a kind of emergency budget, and is asking for an opinion on this issue. And I think this is a really important question. What do we do about individual member states needing to cut emissions very, very rapidly to stay within that budget, and some of these questions, and how do we think about feasibility and responsibility, and whether those things are always the same. So that's the first question. The second question is a quite practical question about what will happen with the pending cases that are relevant to climate change before the European Court of Human Rights that were adjourned prior to the Grand Chamber decision, and whether they have to wait for implementation of the Swiss case to deal with them. And maybe Başak, that's one you could answer. And then there's a final question that I was interested to put to you all on how the three decisions from April the 9th affect government framework cases before national courts. And this questioner is asking specifically about standing for individual plaintiffs. And in their interpretation, the European Court has ruled this out. I think, of course, my point would be that actually will depend very much on national standing rules as to whether or not these applications can be applied. But I think that the broader question is very interesting one. So I don't know, Floris, maybe you want to go first on that question about the 1.5 degree temperature target, and then we'll see who wants to come in next.
Yeah, thank you, Kate, and thank you for this question. It's a really good one, and it's a really important one. But I do want to stress that I think we cannot give up on the 1.5 degree threshold. And I also think that this really underlies the court's judgment, because the only way that you can actually use the carbon budget as a useful concept is if you accept that there is still some budget left, and we haven't reached 1.5 yet, so there is budget left. Now, when it comes to how you should deal with the fact that we've almost depleted the budget, and that under most metrics for fairness, European states may have already exceeded their fair share budgets, I think it's useful to also look at the report published by the European Scientific Advisory Board on climate change, which was established under the EU climate law. And this is the body that advises the EU on its reduction targets. And what it has done is it's looked at what is the highest feasible reductions that the EU can achieve. And it At the same time, it has also looked at what a fair share carbon budget for the EU will be. And then it concludes that the highest feasible reductions still leave a shortfall with what would have been fair. So essentially the EU will exceed its fair share budget. And what it says you then have to do is achieve your highest possible ambition within your own territory, and then compensate for the shortfall. So all of the emissions in excess of your fair share budget by financing reductions abroad. And I would stress that this only works if you do actually achieve your highest possible ambition, the highest feasible reductions in your own territory, because the remaining global carbon budget is so small that you can't just be buying off your own reductions by financing it elsewhere. And you have to do both at the same time. And in case your national budget is already depleted, then you have to compensate for all of your emissions. That's the only way that this can work. So that will be my response to that question. Then, Kate, do you want me to address the final question as well?
Yeah, absolutely, if you'd like to.
I think the three decisions by the European Court of Human Rights actually provide a great prospect for climate litigation moving forward, also in national courts. I won't go into why that is on the merits, because that was what my presentation was about, essentially, because it just lays down a really strong norm when it comes to quantifying a fair share 1.5 aligned carbon budget. But it also signals really clearly in paragraph 639 that what the court wants is for national courts to pick up this issue of climate litigation. And it refers at length to existing climate litigation at national level. So what it certainly wants is that these cases don't all come up to the European Court of Human Rights. No, it wants these issues to be litigated at national level. And I think that's also, I agree here with Kate, this is also where rules on standing at national level come in, and where individuals may be able to bring claims, and where certainly NGOs can be set up, or already existing NGOs can bring claims before their national courts. I would also mention, and this goes into a little bit the other question, is that there is now a case pending before the European Court of Human Rights, Mühlner versus Austria, which is about an individual plaintiff who suffers from multiple sclerosis and Uthoff syndrome, which means that as outside temperatures rise, his symptoms of paralysis increase. So as the outside temperatures increase, he is restricted to a wheelchair, or he can't leave the house at all. And this may very well be an individual who meets this really high threshold of victim status that the court has set. And I think that case will also show how the court actually approaches the issue of individual victim status, and whether it might widen that a little bit to allow for this type of litigation.
Thank you very much, Floris. And I think that last response goes to the final question about what might happen with the cases that were adjourned until after the Grand Chamber hearing. I don't know, Başak, if that's something that you want to come in on, and then any of the other points that you want to respond to as well.
Yes, sure. So the legal adjudication processes at the court and the implementation processes at the Committee of Ministers are two separate processes. So they're not linked to one another. So the implementation of this case will not affect what the court will decide on, when it deals with all the other cases. So they are two distinct stages of adjudication. One is implementation, the other is just looking at the case. Having said this, though, this could impact if Verein KlimaSeniorinnen wanted to bring this case again before the European Court of Human Rights. So this is maybe a little bit more technical, but if a victim's case is being, is part of the implementation process, the European Court's jurisprudence says that you can't bring this case again to the court because it's now subject to implementation. That it's ongoing implementation. You can't be impatient. You have to wait until the implementation process is closed. Which means that if this implementation process is prematurely closed at the Committee of Ministers, the same organization can go back to the European Court of Human Rights. So that's a very, that will have an impact on the organization in Switzerland. And also on the question of standing, this is a really important question, but I think the 3 judgments that the court delivered on the same day, including a case against France and Portugal and 32 other member states, I'm not so sure if it de facto ruled out everything, in terms of standing of individual plaintiffs. So just to say that I think there may be other ways of thinking, what the court did, but I don't think it's definitively ruled everything out. As Floris was saying, I think this is an area that we will have to see how the case law of the court may develop. And hopefully, this also means that domestic courts don't misunderstand what the court has done in April 2024 and kind of go to a race to the bottom, that there's only one way to litigate these types of cases. But these are things we will have to wait and see how the domestic courts everywhere in Europe also digest this judgment and hopefully don't misunderstand or have a very minimalistic understanding of what the court has done.
Thank you, Başak. Yeah, I think that's a very important point. That this is not necessarily something that needs to be read in a way that excludes all avenues. Vetle, do you want to come in on any of those points, the 1.5 degree temperature?
Yeah. A few points from me. Yeah, in relation to the 1.5 degree, I very much agree with everything Floris said. I think it's true that in many ways to calculate the carbon budget, many European countries will already have used their fair share. But that's, which I talked about, where the relationship between emissions trading and domestic reductions really comes in. States can have the highest possible domestic ambition while still reaching their carbon budget by, for example, emissions trading or climate investment. And I'll comment a bit on the effect of the 3 decisions before national courts. I think the Norwegian rules on standing are quite comparative, so I don't think it will have a huge effect on that, but it's already had an effect in the procedural and merit and the procedural and substantive requirements the court set out under the merits. It's been referred in a case which there's a case in Norwegian courts where with a temporary injunction against 3 new oil fields. The procedural rules the court set up was referenced there, and I'm pretty sure when that case comes up on the merits, it will be referred as well. Obviously, in relation to standing, or the Duarte case was rejected on jurisdiction and not really on standing. And I think that's also very interesting. Essentially, the court rejected extraterritorial obligations. And that has created kind of an interesting split between the European Court of Human Rights on the one hand and the UN committees and likely the Inter-American Court of Human Rights on the other hand, because the UN committees and the Inter-American Court of Human Rights have taken a more extensive view on when states can have extraterritorial obligations. So this is an area where it will be interesting to see what the International Court of Justice says, for example, and where national courts, if they try to interpret whether states can have extraterritorial obligations, can take inspiration from different sources.
Great. Thank you all so much for those answers. And I'm afraid we have many other questions in the chat, but we are running out of time. So we won't be able to get to them all. One question that I did spot, though, was how can people follow what happens after the meeting of the Committee of Ministers in March? And I think that's probably a good question for us to leave this webinar on. So Başak, I don't know whether you feel you could answer that, or maybe Floris as well. Yeah, over to you.
Yeah, sure. So I'm assuming that this is an audience that's interested in the European Court's judgment, so they will know that there's a website called the HUDOC website where one can read all the judgments. Now, the Committee of Ministers and the Execution Department also has a website called HUDOC X, so it's HUDOC Execution website. So all the information that is going to be upcoming about this case about its implementation will actually be uploaded onto that website. So, the best way to keep updated if you want to know what's, what is the public documents, not what happens in the diplomatic corridors, during March or after, is to log in. It's an open access website, HUDOC execution website. Type in the name of the case, and you will see then the action report, NGO submissions by the Verein KlimaSeniorinnen, notes by the Secretariat, technical notes about what they think this judgment really requires, as well as the decision of the Committee of Ministers. And they are usually made public just a day or two after each session of the Committee of Ministers. So they could all be followed via the HUDOC execution website.
Perfect. Thank you so much. Well, I think we've seen from today's audience participation and the number of questions, the number of people attending, that there is going to be real interest in what does happen in that session in March, as well as what happens in national courts and in national political processes following this decision as well. So thank you all so much for sharing your insights today. It's been a real pleasure. I'm sure we could have kept talking for much longer, and thank you to the audience members who joined as well. We will continue following this at the Grantham Research Institute, and we hope to be able to provide further updates and opportunities to discuss the case. Thank you, everybody.